A historic day across our country as the Supreme Court overturns Roe v. Wade. This battle over federal abortion protections that has played out for the last 50 years seems to have finally come to an end. And tonight, protests are in full force all across this country. Tonight, my co-anchor Dustin Grove is live at the Indiana State House as the news plays out here. Dustin.
Good evening, Anne Marie. We have seen the huge crowds outside the steps of the Supreme Court building, and this landmark moment essentially removes federal protections for women when it comes to abortion services, meaning that it is now up to every individual state to decide if women can get an abortion, and if so, when they get it and how they get it.
What's next will look drastically different depending on where you live.
Yeah, that's right. And I believe we have sound from President Biden earlier this afternoon talking about this monumental moment.
State laws banning abortion are automatically taking effect today, jeopardizing the health of millions of women, some without exceptions. So extreme that women could be punished for protecting their health. So extreme that women and girls were forced to bear their rapist child.
The pro-choice emergency rally has just started here on the circle. I'm going to step aside so you can have a better look. You can see that people are waving signs that say free legal abortions now and legal abortion once and for all. And whether you're pro-choice or pro-life, the Supreme Court's decision to overturn Roe v. Wade has both sides expressing strong reactions today. Kurt Smith with the Indiana Family Institute says today is a good day. He is a pro-life advocate and the chairman of the board for the Institute. Its mission is to be a voice for families in Indiana and have a biblical traditional view. He's been on the front lines of this issue for 40 years. Smith says he's not surprised by today's decision, but gratified.
It's been very incremental. That's the nature of American public life. You take steps, and some might see this as a radical step, but it's really just saying there's no longer a federal policy that'll be defined by 9 justices. All 50 states, the territories, now have to work through.
The Women for Change CEO, Rima Shahed, says she's disappointed by the Supreme Court's decision, but not surprised after the leaked draft from earlier this year. Now that it's here, she wants to encourage women not to give up and to fight even harder.
For those that are maybe celebrating today, it took 50 years. It will be a long, hard battle. I'm not going to sugarcoat it, but we will stay on track because we don't know of any other way than to make sure that we have equity for women, and that includes and women's right to make health care and reproductive choices about their own bodies.
Smith says the next step for pro-life Hoosiers is to work with the legislature to get strong pro-life laws and help mothers and fathers. And Rima is urging pro-choice Hoosiers to remember how they're feeling today and carry that feeling on to November and all elections. Back to you.
All right, Logan, thanks so much for reporting live from Monument Circle. As you can imagine, this is also a hot topic for those that work in the medical field as well. Today, our Rich Nye talked with a doctor at IU Health to learn how this could potentially impact patient care. Rich?
Yeah, Anne-Marie, doctors who perform abortions as part of their OBGYN practice are now preparing and expecting new restrictions on abortion in Indiana, perhaps up to a total ban. Now, a group of healthcare providers earlier this month went to the State House and delivered a letter to the governor asking him not to call a special session of the legislature to consider new abortion laws and to protect abortion access. That letter was signed by about 300 healthcare providers. With the confirmation and now the official ruling of Roe v. Wade being overturned by the U.S. Supreme Court, these doctors are preparing for patients to have less access to abortions in the near future.
We know that this is going to be bad for the health of our community. That's really what it's about. This is about health care. As an OBGYN, I have a duty to care for and to protect my patients. And we know that Roe versus Wade is going to make that incredibly difficult, both for women who need abortions and for women who need other care. You know, health care in a pregnancy is not black and white. There are lots of difficult circumstances that we need to take into account. And this will make it very challenging for us to provide that healthy care. And to prevent what we all want to prevent, which is maternal mortality.
Dr. Caitlin Bernard actually just returned from maternity leave herself. She teaches here at the IU School of Medicine. She says her responsibility for now is to educate the public and to continue to provide the best care possible to pregnant women, including abortions when appropriate, until Indiana law is changed.
Rich, thank you. And another big concern tonight, Dustin, is the potential domino effect that this ruling could have on some other rulings about same-sex marriages and also contraceptives.
Yeah, that's right. In fact, Justice Clarence Thomas, in his opinion, argued that some of these issues should be reconsidered. So our Verify team took a look at that part of that story and how it may play out. Take a look.
Abortion rights were up for discussion in the Supreme Court this term because of one case, a challenge to restrictions in Mississippi. It's also about the Constitution of the United States and what rights are clearly defined, which are implied, and which are not protected. The Roe versus Wade decision back in 1973 came down to right to privacy, which usually rests on due process rights in the 14th Amendment of the Constitution, which protects the right to life, liberty, and property. But this latest decision says the right to an abortion was wrongly considered an implied constitutional right in Roe versus Wade. So let's verify. What other decisions rest on those implied rights? Our sources are Caroline Fredrickson, Georgetown law professor, and Robert Peck, constitutional law expert at the Center for Constitutional Litigation.
There's an interesting philosophical decision that's embodied in this opinion, and that is, to what extent are rights implied by the Constitution? This opinion asserts that abortion is not one of those implied rights.
There are other subsequent decisions dealing with equal marriage, gay marriage, and so forth that rest on the same foundation.
The idea of an implied right to privacy is the foundation of these other big decisions, like Obergefell versus Hodges, the case that legalized gay marriage, and Loving versus Virginia, the case that legalized interracial marriage, as well as Griswold versus Connecticut, which affords married couples the constitutional right to buy and use contraceptives, and Lawrence versus Texas, which made same-sex sexual activity legal in 2003. As for whether those cases are at risk, it's hard to say. Justice Samuel Alito argued the abortion issue is, quote, critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. But for nearly 50 years, abortion had been considered a procedure that fell under the implied rights umbrella.
It basically is an invitation to those who oppose those decisions to come back to the Supreme Court, frame your arguments the same way that this case, the opinion in this case, was framed, and then see if you can get the same result.
So while some legal analysts say those other rights are addressed in the majority opinion, others are concerned this decision is like a roadmap for overturning those rights as well. The Supreme Court decides what rights are guaranteed in the Constitution, explicit or implied. With your Verify, I'm Abby Larico.
Thanks, Abby. Now, keep in mind this landmark decision essentially removes federal abortion protections for women, meaning it's really up to the states as to what happened next. For tracking what's going to happen here and these so-called trigger laws, let's get over to Dustin.
That's right, Anna. We want to be clear. Today's decision really doesn't change anything right now for the state of Indiana. That's because we don't have what's called a trigger law. A trigger law is a law that immediately is triggered or takes effect as soon as the U.S. Supreme Court makes its decision. We want to put a map up on the screen here to show you a number of states do have these trigger laws. That means those abortion bans, individual abortion bans in those states, are now in effect. As for our state, Indiana lawmakers will be returning here to the State House on July 6th for a special session. They were already headed here to take a look at some economic issues, but on Twitter today, Governor Holcomb said they will also be taking up this issue as well. I want to show you what he said on Twitter in his statement. He said he expects lawmakers to use this special session to address abortion, adding, quote, "I have been clear in stating I am pro-life. We have an opportunity to make progress protecting the sanctity of life, and that is exactly what we will do." Now, on the other side of the aisle, Democratic state lawmakers say they plan to make their voice heard to oppose this Roe v. Wade decision and stand strong when it comes to abortion rights. I want to put up a statement from Senate Minority Leader Greg Taylor earlier today saying, quote, "Regardless of what happens in our upcoming special session, my caucus will never give up fighting for essential abortion care for all women." That special session scheduled for July 6th, a week and a half from now. Ann?
All right, thanks so much, Dustin. There is just so much to unpack here on this topic, and tonight we are just getting started. Don't forget, you can always follow along with the very latest updates on this story by going to the WTHR app.